Okay, so this is week 4, the trademarks week. And yay, because I love trademarks. I know it seems crazy to get kind of worked up about trademarks, but they're a nice little IP right. They're relatively cheap to acquire. And because the whole function of the trademark system kind of dovetails very nicely with the government's policies on keeping consumers well informed and not having consumers misled or deceived. And, they're not as perhaps offensive an IP right to many as much as, for example, patents or copyright. So they're a friendly little IP, right? And they're obviously not too friendly if you're facing an infringement action or if you're facing an opposition by one of the major, brands out there that's aggressively trying to protect its trademark. And one of you guys, I think it might have been Bianca, found another attempt by McDonald's reported just recently to squash a poor little Indian curry restaurant from using the name McCurry because, you would definitely be confused if you were sitting in an Indian restaurant by the name of McCurry and somehow be tricked into thinking that restaurant was owned or operated by McDonald's. Go figure. So what I wanted to do just before we jump into the problem question was just have a bit of a chat about trademarks more generally and whether you guys had any questions or queries in relation to the way trademarks work, the way that they're registered, all of that kind of thing. Was there anybody that had kind of some general trademark related questions? No? What about you, Joselito?
I don't have any specific things, but I find it quite artificial, basically. People create property rights, well, not property rights, but a right to something out of combination of words, sort of, yeah.
You find the whole idea of propertizing words a bit difficult, a bit artificial?
Yeah, it's kind of artificial, although, it's just basically a combination of words that is part to the society but then I don't know really the value of those words. Like, for example, in, what was that? The competition, the Taylor, Swift Taylor, basically, she applied for that, how do you call it? Her favorite lyrics in her album. I don't sometimes get it. What does she want? So,
she wants to be able to sue other people for infringement. I totally get it. I totally get that concern about fencing off parts of the English language for exclusive use by a trademark proprietor. I can totally get how that seems artificial and, in fact, perhaps a little bit scary. And I'm really glad that you brought that point up because it leads very nicely into a brief exploration as to what you can and can't get in terms of a registered trademark. What I'm going to do is I'm going to be real boring and share my screen now. And I'm going to take you to the Trademarks Act. Now, there we go. Now, can you guys see that? Can I get a heck yes from someone?
Yes. Yes, I can see that.
Sweet. So if we go down here to Now, the requirements for trademarks. Now, firstly, if you have Joselito, do you want me to call you Joselito? I noticed that on the forums you're posting as Jack. Did you want me to call you Jack?
Yeah, either Joselito or Jack, you know, as long as Joselito is pronounced properly.
Okay, you can keep me on tabs. If we have a look at what is a trademark, right? It's a sign used to distinguish goods or services. And that phrase, distinguish goods or services, is super duper important in the Trademarks Act. You actually can't get a registered trademark for a sign that is not capable of performing that function, that is distinguishing your goods or services from somebody else's goods or services. So like I said in the video for this week, you couldn't get the trademark Apple for apples. And this is the whole, I have a point here. And it gets back to Joselito's comment about, you know, shouldn't the English language kind of be free for all to use? You're only going to get a registered trademark if, in fact, other traders in your industry would not need to use that particular term that you're asking for. So as I said, you couldn't get the trademark Apple for a variety of apples, okay, because other apple growers are going to need to use the word apple in relation to their product. So that's just going to be rejected straight away. However, as I also say on the video, if you use the word Apple for computers, it has no necessary connection with that product, and other traders in computer production don't need to use the word Apple in relation to their computers. Apple is a very distinctive word when it comes to the product of a computer and a phone, a laptop, or any other number of Apple products. So it is very distinctive of that particular source for that particular product. And that's the only reason why they would be able to get that registered mark. Now, if you also have a look here in terms of, where are we? Grounds for opposing. There we go. Now, I'm used to the old numbers. There we go, 41. An application for registration must be rejected if the mark is not capable of distinguishing. Okay? So where you have an application, something like what? Carpet World. For carpet, it'll be rejected because it's not really capable of distinguishing. I mean, the fact that you're selling carpets in a large, warehouse and you want to call it Carpet World, well, the problem with that is there may well be any other number of retailers that also sell in similar circumstances the same kind of product. So Carpet World is really not terribly distinctive of the activity of selling carpets, okay? It wouldn't really be capable of distinguishing. Now, here you've got to note that you have, there we go. This subsection applies if the mark is not to any extent inherently adapted to distinguish and the applicant hasn't used the mark before. Okay? The section also applies if the mark is to some extent but not sufficiently adapted to distinguish and the mark doesn't and will not distinguish because of the amount of use it's had and the lack of distinctiveness, okay? Now, that might seem a little bit confusing on first blush, but what Section 41 actually does is it provides, and I guess it's not terribly clear on the face of it, there is a presumption that your mark will be distinctive unless the examiner is satisfied that your mark either falls into Section 41.3 or 41.4. And the beauty of this is pretty much you're going to get over the hurdles of 41.3 and 41.4 if there is some extent to which your mark is distinctive. And if it's inherently distinctive, like, for example, what's a made-up trademark? Kodak, okay, for film processing services. Now, that's a completely made-up word for those services. It's going to be inherently adapted to distinguish, big tick, registration, no problems. However, if your mark is less distinctive than that, I mean, there is a very big grey area between calling, between applying for the word apple for apples and the word apple for computers. So there's a big grey area in between. And what the examiners have to work out is exactly how distinctive is this mark that you're applying for, and would other traders need to use it, or is it something that really is only going to be associated with your particular goods, okay? And this whole idea of distinctiveness, to get back to Joselito's question, is really important because it avoids the whole trademark registration system fencing off parts of the English language that other people might in fact want to use. So that was a kind of long-winded way of answering your question, but did it make sense, Joselito?
Yeah, it does. Yeah, certainly.
Yeah. You're not going to be able to get a trademark, a registered mark for something that other people are going to need to use. Unless, and here is one big exception, unless you have so much use out in the marketplace that immediately anybody sees your particular mark, even though it's more descriptive than distinctive, they're only going to associate it with you. And there was an old case in, I think it was the 19th century. They got the trademark camel hair belting for belts made out of camel hair. And the only reason why they could do that, even though it was so descriptive, was because there had been so many years of use out in the marketplace under the mark camel hair belting that the moment anyone saw that, they only ever thought of the applicant's goods. Okay?
Hey, Amanda.
Yes, hello.
Hi. Could you just say with that made-up example, the carpet world, could you just spell carpet world with a K?
Yes, you certainly could. And
that'd be cool. That's registrable.
That would almost certainly satisfy your any objections that were made by the examiner. They love anything like that. Contractions, misspellings, anything that's different and strikes the eye. It would also help if their logo had, if they had a drawing or a logo attached to it to make it more distinctive again. But obviously the more embellishments that you add to your mark, so the more drawings or stylized pictures or whatever you've got adorning the words, the more specific your mark's going to be. And if you want to sue somebody for infringement of that mark, you need to make sure that if you want to sue based on the letters, the words, you're going to have to make sure that they're the prominent part of the mark that really hits you in the face.
Okay.
Do you see what I mean?
Can you trademark a colour?
You certainly can, yes.
I heard someone say that a lecturer in some other subject said Eagle Boys trademarked a certain shade of pink or something, or red, or a warm tone of colour for their logos, and I didn't know if that was true or not. It probably was.
Look, do you know what? I have a funny feeling that was the case. Wouldn't you know it? I'm in the Trademark Search. I'm in the Trademark Search engine now. Let's have a look for Eagle Boys. They've got, wow, they've got a few. They've certainly got a logo there that's got the pink background. They've got another logo. Look, all of these.
Can I just, while you're looking for that, can I just mention something? Now, I don't know where I found this, if it was in one of your videos or might have been on YouTube or something, but there was a football team in America that actually trademarks the colour of their turf.
The colour
of their football field. It's blue. It's a particular shade of blue.
That's amazing.
That wouldn't surprise me. You know, most things get through in the US. I'm not necessarily sure that all of them are terribly good trademarks, though. However, I guess you got to admit a blue turf on a footy field would be fairly distinctive. Not. This is where you run into your issues. And just before I run on to that, Jacob's point, Cadbury Schweppes. If you think of Violet Crumble, does a certain shade of purple pop into your mind? Yeah, that shade was registered by Cadbury after some fairly extensive legal battles. But this is where you've got to, this is why I started off the whole, and thanks to Joselito for prompting me, the whole issue with trademarks is that tension between what's going to be distinctive enough to avoid any objections by the examiner, but at the same time, a really good mark will kind of wander away from something that's completely distinctive, like I said, Kodak for film processing services. Now, it's going to take a while to educate the public that Kodak means that particular good or service, isn't it? Because it's a completely made up word. But really good marks will be kind of suggestive of the product, suggestive of the services, but still distinctive enough to get over the hurdles that the examiner will put up. And that's where you start to get your misspellings, you know, your E-Z-loans, you know, that kind of thing. It's a tension, and often you'll find that this tension is really, it comes to the fore in pharmaceutical trademarks, because you'll often get a pharmaceutical company wanting to have something that fits with their family of marks and is distinctive, but at the same time, once a GP hears the trademark, they will be reminded of either the properties of the drug, the main ingredients of the drug, or some other characteristic of the drug. And this is where you get that tension, you know, what's distinctive, what's descriptive. And if you wander too far over to your descriptive end, you're just going to be rejected. But in the US, they seem to, and the other point with having marks that are too descriptive, I was just going to say, in the US, you know, they seem to register almost anything. I've said online on the forums and in a few other places, you know, I really question the cost and expense for things like McDonald's registering "I'm loving it." Yes, you might think of McDonald's when you hear that phrase, but at the same time, and they might have got it over the registration hurdle, but how effective is that going to be when it comes to trying to sue someone for trademark infringement? Because what you're going to have to do in Australia anyway is prove that that person, when they were using "I'm loving it," was using it as a trademark. And, you know, most uses of the phrase "I'm loving it," I mean, you know, I say it almost every day, are not going to be actionable because you're not using it as a trademark. So there you might be able to hop over the registration hurdles and get your registration, but how effective is it really? And that's where you have the distinctive descriptive tension, and where you have a descriptive mark or something that's often used in everyday language like "I'm loving it." I mean, how effective is that going to be as a trademark? Because I just query how easy or hard it's going to be to enforce that mark. You kind of get where I'm going there? So, interesting. Yes, we do have that tension. As you can see, I was looking up the Macca's mark. They have like a whole family of marks. Again, in Australia, I guess if you see the word Macca's, you know exactly who we're talking about. But I'm loving it. I don't know whether it's going to be quite so distinctive. Now, do I have no chat here? I thought I had someone telling me something. Okay, so any other, the other thing I wanted to show you about this particular registration was you all realise, don't you, that when you register a mark like this, you're not just registering the word as a word, you are registering the word in a specific class for specific goods or services. Okay? And this is something else that I guess locks in the whole distinctive requirement, because you are looking for that word being distinctive for that class of services. Okay, and there's a whole stack of classes which you can look up online, and that's the way you go about registering. Also, have a look here. The mark was registered in while the 1955 Act was still up and running. And we had two different parts for that particular trademark register. We had the goods register and we had the services register. Okay, so that's why we've got that endorsement there. Were there any other general type queries with trademarks? No? I might skip over then to my Word document for this week, and we'll go back to dear old Nigel and Roy, who we know and love. And this week we are specifically looking at the problem facts and pulling out trademark issues. So we know that Nigel and Roy get this burger operation going. They call it Hungry Max. They do use yellow and red, which is something to note. They do go ahead and file a trademark application, which is accepted and published in the Gazette. Okay, now there I just want to flag for you. So just because you jump over the hurdles of registration doesn't mean you're home and hosed. Okay, what happens is your trademark is advertised in the Gazette and it's basically thrown open to all the world. And you'll find that all of the trademark attorneys will have alerts the moment that the Gazette, the new Gazette comes out. They will go through the Gazette for their client base and they will have a look at any new acceptances that might pose a problem for any of their clients. And what anyone can do is once that your mark has been advertised, accepted in the Gazette, they can then go ahead and oppose your application. Okay, and that can be a very long and drawn out process. Certainly was when we were trying to get McBratt across the line, and McDonald's decided to oppose the trademark registration. It can drag on for, you know, more than 12 months. But if you manage to get across the line after your opposition and convince the examiner that it should still be registered, then the examiner will actually go ahead and place your mark on the register. Okay, so we know that Nigel and Roy have been fairly smart. They have filed the application and it's been accepted. Okay, so what objections would Mary make to Nigel and Roy's trademark application? What did they actually apply for? Let's have a look over here. They chose the name Hungry Max, which appears to be in yellow and red, much like Hungry Jack's. And in fact, McDonald's is yellow and red as well. And we know that they filed an application for their name. So what was Mary's input here? What did she do? Did she come up with the name Hungry Max?
She's the author, isn't she?
No, I think she just did the logo.
Oh, I got the logo confused.
Yeah, that I sneakily did that in order to confuse people. Dang it. So we had Mary designing the interior menu layout, including a logo. Okay, so she's got this man with the thumbs up, cheeky smile, and references to Hungry Jack's, KFC, and so on. So we know that the application related to their name. So do you think Mary could do anything about registration of the name? What rights does she have? What did she actually do?
Well, she did design it, but I don't know if she actually owns it. I suppose she does if she thought of it or came up with it. Does she own it?
She would definitely own the logo. The man with the thumbs up and the cheeky smile and the wink, certainly. And we've also got, what rights to that? Would it be trademark rights that she has? What rights in that drawing does she have?
Copyright.
Yes, thank you, Jessica. She is the copyright author of the logo. Okay. Now, we also had a little look at whether or not, when we were talking about copyright the other week, we had a look at whether or not we thought that that slogan that accompanied the logo might be potentially protected by copyright for her as well. And remember, we had a look at those cases that had to do with titles of newspaper articles. And we said, well, it's probably a little bit more creative than those logos, although than those titles of the newspaper reviews where copyright was denied. So she would definitely have copyright protection and copyright rights to the logo and potentially the slogan. But is that going to, if all that Nigel and Roy have applied for is their name, is she going to be able to do anything about that? Who came up with the name?
Nigel and Roy.
Yeah, that's right. So, assuming that they just chose the words Hungry Max for their trademark application, then I don't necessarily think that she's going to be able to argue that she can interfere with their application. Now, I'll put down here, it appears Nigel and Roy only applied for the name Hungry Max and not the logo or the slogan, which would belong to Mary as copyright author of those works. Yep. If they only applied for the name, then Mary wouldn't be able to interfere. Application. If, however, and this is something that gets back to what Jacob said, they applied for Hungry Max plus the logo. And you know how you often will see, if I say to you, and I'm sure this is kind of freaky how this happens, but if I say to you the words Bob Jane Tea Marts, what picture do you get in your head? Do you get a picture? That's crazy, isn't it? I know. So there you have a logo that is really intimately bound up with the words, don't you? You have that kind of trademark, you know, fix-it guy that's staring back at you. So if they applied for the Hungry Max plus the logo, what could Mary do? Let's go back to the legislation.
Well, she'd be able to oppose it, wouldn't she?
She would. On what basis?
Section 42, I suppose.
Section 42. Contrary to law. Is that the one that you were thinking of?
Yes, because she's the copyright holder.
I think probably...
Would it be 58, not the owner of the mark?
That's the one. That's the one. The only problem with trying to allege, I mean, that's good lateral thinking, Joselito. The issue with that, though, is that you would then have to go ahead and prove all of the elements of, for example, Section 18 of the ACL, and you'd have to go ahead and demonstrate that consumers would be either misled or deceived. And we'll get on to Section 18 next week. I'm just finishing off the video for that, actually. And, you know, unless there were enough consumers out in the marketplace that were familiar with her work in that logo, I think you'd be pushing it uphill to get across the line with Section 18 ACL. So I think probably 58 is your natural kind of go-to section. And this certainly was the section that was, when I was in practice, we had, does anybody remember, I don't even know if it's still around, the brand Golden Circle? Is anyone familiar with that? There was just some corporate, corporate movements that went on with Golden Circle, and they finally decided to register a trademark. And it turned out that, would have been 10, 15 or more years ago, the logo that was well associated with their mark had been drawn by someone else, and there had been no assignment of copyright in the mark. And this is the section that causes you problems when that happens. So that is typically when the copyright owner will step in and say, money please, I would like an assignment to occur before you can go ahead with your trademark application. Okay, so she would oppose registration. Nigel and Roy don't own the trademark logo. Yes? Makes sense? Chances of an opposition by McDonald's or Hungry Jack's succeeding. Okay. What do we think about that? Let's go back to our grounds for opposition.
I would say under section 60 it'd be highly likely.
Yes. And there is also here 44. Oh, I'll just take you back to, okay, so grounds for rejecting an application. Here, all of those grounds for rejecting an application can be used in opposition. Okay, so where you've got something like here, an application must be rejected if the applicant's mark is substantially identical with or deceptively similar to a mark registered by another person. Okay, so there, Macca's would be saying, well, hang on a minute, Hungry Mac's, we think that's too similar to, for example, Macca's. What do you guys think about that? That's the argument they'd have to use though, isn't it?
Probably 50% of the population will think that it's Hungry Jack, and 50% of the population will think it's McDonald's.
I know, right? Oh, who drafted this question? I think Macca's would probably be the closest one. They might argue McDonald's. I mean, the test is here, would you be, what's the terminology here? Would you think that it's substantially identical or deceptively similar? I mean, if you saw Hungry Mac's and then you saw Macca's, do you think that's potential for deception?
I think the average consumer's a lot smarter than that, though, to some extent. But you probably will catch some people some of the time.
That's right. I love that. What's that beautiful case in the old Section 52 case law? Was it Star newspapers where they said you have to consider everyone but a moron in a hurry? I think the average consumer is not a moron in a hurry. And would they be confused? I don't think so. Hungry Mac's. If I saw Hungry Mac's, do you know what? There is a case, and I think, we're testing my old case law memory now. I think it's Burley Bras and Barley Bras. And ladies, you'll probably be aware of those two brands. There are different arguments that are made where you have oral similarity. And in terms of similarity, usually the first part of the mark is what sticks in consumers' minds. So for me, certainly, if I saw Hungry Mac's, I'd be much more likely to confuse it with Hungry Jack's than Macca's, for example, or McDonald's. Okay, so if we go back down here to Hungry Mac's and Hungry Jack's under Section 44, again, I probably should put Section 44 up here. What do we think about that? Oh, there is another provision that might apply too here. And I think, yeah, 60. Someone said 60. Usually 60 will be used for well-known trademarks rather than other registered trademarks. But contrary to law is that lovely one here. There. And that's the one we were talking about with Joselito before. It sweeps in Section 18 of the Australian Consumer Law. So they would be arguing Section 44 that their mark, Hungry Jack's, is deceptively, or that they wouldn't be arguing their mark, the Hungry Max mark is deceptively similar to their mark Hungry Jack's. So that would be that argument. And Section 42, it would be contrary to law because it would be misleading or deceptive under Section 18 of the Australian Consumer Law, is what they would be arguing there. Now, I certainly think, and what you've got to do there is you've got to say, well, what's the similarity here? We're looking at Hungry Jack's as opposed to Hungry Max. And here I think the argument is probably a lot stronger. Yes? Yeah?
Is it supposed to be Section 43 instead of Section 44?
Section 43, you can, yeah, if because of some connotation in the trademark or a sign contained in the trademark. Now, normally this particular provision is used where it's not necessarily the black and white meaning of the words that's misleading or deceptive, but it's some secondary connotation in the mark or perhaps an associated logo that would tend to mislead or deceive. That just tends to be where this particular provision is used. The one that normally will be used to sweep in Section 18 of the ACL is this one here. Okay? So you'll see the word connotation. So, oh goodness. See, sometimes trademark law devolves into a really picky grammatical construction, but you've got a word, and what a word would ordinarily mean is called what it denotes, okay? So an apple denotes the fruit apple, yep. But where you've got a trademark or a mark or a sign that's being used in trade, like I said, where you've got not necessarily the direct, denotation of those words, but something underneath, a connotation, that is what this provision is directed at. It's perhaps a little bit more sneaky an association that's being used to mislead, okay? Not usually what's the black and white meaning of the words, that denote something, okay? So that's the difference. Denotation is your direct meaning. Connotation is something that kind of floats underneath the surface but still carries some suggestive meaning. So 42 is usually the one that's used to argue Section 18 or Section 29 of the ACL. What do we think about Hungry Jack's and Hungry Max? Do you think you'd get up on something like a Section 18 analysis of that? Do you think we'd be confused? What are the kinds of principles that we play around with with Section 18. Can we remember? It's a long while ago now, isn't it?
Misleading, deceptive conduct.
Misleading and deceptive conduct. And you're thinking about things like, if you can recall, do you remember in contract talking about the Parkdale and Puxu case? Yeah, the PP case, Parkdale and Puxu. In that case, which was very helpful, they were talking about purchases of very expensive lounge suites. And they talked about, you know, where someone's going to buy an expensive lounge suite, they're going to probably make sure that they're getting the one that they want. So even that relatively small label on the lounge suite itself was probably enough to dispel any confusion because of the nature of what you're purchasing. However, they said where you've got something that's more of a commodity good or service, and consumers are going to be buying and selling this thing. I mean, you know yourself, how often have you gone into a cafe or a deli and you've grabbed something out of the fridge and you've thought, oh yeah, that's what I want. You know, you might have reached for what you thought was a Coke Zero and it was in fact something else. It's because you're making the purchase with much less care and attention than if you were going to buy, you know, a $2,000 or $3,000 lounge suite. And so there you're talking about a much lower level of analysis that goes into, you know, the average consumer looking at the trademark. Okay, so it's going to be much easier for that kind of confusion or deception to occur, isn't it? If you're just making a quick purchase in a cafe. Okay, again, if you saw a large sign out the front of a burger shop that was in red and yellow and it said Hungry Max, I mean, you've got two letters essentially that are the difference, haven't you? There's a J and a K added to the second word. So you're relying on the fact that consumers are going to look at that second word and that they're also going to make the distinction between Max and Jax, aren't you? I think the argument would be easier for Hungry Jack's than McDonald's. I think there's probably more likelihood of deception here. However, they would have to get up in front of the examiner and argue successfully that that was the case. Okay. I don't know. I'll throw it open to you guys. What do you think? Would you be confused? Have you ever driven into a drive-through place at the dead of night and perhaps confused something? Do you think you'd be confused?
I'll probably be more curious than confused.
We don't actually have a drive-through situation here, do we? And the other problem, I think, for I'll put here at least externally. But what do we have on the interior of Nigel and Roy's establishment? What colours were the interior? Can you recall? I'll go back up here.
Yellow and red and yellow.
It was blue and white.
Yellow and red.
Now, externally, they used yellow and red, and internally, they used blue and white. So even if you went, and to me, I don't know why, does this happen to anybody else? But if you walk into a food retailer and the interior is blue and white, I immediately associate that with fish and chips. I don't know why, but if I saw blue and white, if it was late at night and I wanted Hungry Jack's and I walked into that burger joint and then I was hit with blue and white, I think I would immediately know before I'd made my purchase that this wasn't Hungry Jack's. Yes? I think there would be some difficulty. Obviously, in terms of just the plain writing, I think there's probably an easier argument for confusion there. But I think the problem in terms of, you know, perhaps a Section 18 ACL argument would be, would the blue and white dispel any confusion? Or no, because you can't have confusion under ACL. Deception or misapprehension. Query. Yes, I think probably Hungry Jack's would have a stronger argument than Macca's. I'm not necessarily sure that they would succeed under that, you know, Section 18 ACL kind of analysis. They might get further under Section 44 because there you're principally looking at how deceptively similar are the marks. Okay, you're not sweeping in the analysis of, you know, misleading or deceptive conduct that you have to sweep in for Section 18 of the ACL. And that one we've already covered. Tick. ACL. Now, if you want to look at a nice little analysis of this kind of thing, and the case that I actually based this problem on, it was Target Australia and Catch of the Day. And it's a nice short little case, and it goes through a very nice little analysis of the ACL. Okay, so if you want to be all prepared for next week, that's the one you look at, Target Australia and Catch of the Day. To round things out, how would Nigel and Roy deal with Mary's threat? Well, if they were only going to seek registration for the words Hungry Max, then what would they say to Mary? If she tried to oppose?
We don't have a case.
What was that?
But she doesn't have a case.
Exactly. They would say, sorry, we don't believe you could succeed in opposition. That's a very polite way of saying, we ain't going to pay you anything. We're not going to do anything. You know, if the logo was not that important to them, they would just sever the relationship there. If they were seeking registration of the words plus logo, then what would they have to do? She's the copyright owner.
They'd have to pay her.
Yes. Pay her for, and give me the technical terms for what they would have to pay her for. And she is the copyright owner, and they want to secure her rights. So what are they going to ask her to do?
Is it an assignment?
Yes. Okay. And here really is where copyright owners can hold trademark applicants to ransom. That certainly was the case when I was in practice. You know, you would see problems with copyright ownership of logos. And, you know, if that logo has become intimately bound up with that company's reputation and goodwill in the marketplace. I mean, can you imagine? Everyone thought of that logo when I said Bob J and T Marts. I mean, imagine if they hadn't secured the copyright in that logo. And then all of a sudden, you know, the copyright owner comes up and says, sorry, you're going to have to discontinue use of that logo unless you pay me money. And if that logo is really important to them preserving their reputation and goodwill in the marketplace, they're just going to have to pay, aren't they? So there is a real risk, and this is where I want to impress on you. These are the kinds of things that must be attended to upfront whenever you're looking at trademarks. Always ask the question, who owns the logo? If it's a trademark application for something longer, like a slogan, who came up with the slogan? Is there any risk that that slogan may be a copyrightable work, and who is the author of that work? Okay? Saves a lot of heartache and dollars down the track. Okay.
Sorry,
Yeah,
just interrupt.
yeah.
Just curious, but how much would you pay for that? Or is that how long is a piece of string?
It depends.
There's no sort of nothing.
Look, it I was going to say it really depends on the brazenness of the copyright holder.
Okay. How much leverage do they have?
Yes.
Yeah.
And in my experience, it ranged from anywhere upwards of 10 grand. I think the largest one I saw was $50-something thousand.
And would that be complete ownership over those rights then? Or would there be conditions?
Usually, if you're going to pay any money, you would be well advised to ask for complete ownership, copyright, complete transfer of the copyright ownership to the trademark applicant. Yep. So you've got the whole box and dice tied up so far as IP is concerned. Because you certainly do not want any vulnerability of that mark. If you ever want to come to, just thinking from the back end of things, if you ever want to enforce a trademark, you're going to have to be thinking in terms of, and that was a really good question, you're going to have to be thinking in terms of, normally when you sue someone for infringement of a trademark, the person that's being sued will almost always argue back that that trademark is vulnerable to revocation and cancellation. So then you've got to think about, all of the grounds on which a trademark can be revoked and any vulnerabilities that mark might have. So you really got to square away everything in terms of getting the foundations of the mark right before you get it across the line and get it registered. Yep. Because you can see it's like a game of chess. The moment someone gets sued, they're going to look, it's the same as patents, The moment anybody gets sued, what's the first thing you do? You look at getting rid of the problem. So you look at getting rid of the patent. You look at getting rid of the trademark. Now, if you can get that trademark expunged for some reason off the register, boom, your infringement problem's gone away. So it's all just a game of chess. But this is why I say you got to get all your ducks in a row as you get into registration, rather than, down the track, getting to the point of infringement and suing and then worrying about, oh no, they've got all these really good arguments as to why our mark should be cancelled or expunged from the register. Yes? It's fun, isn't it? What are the salient lessons to be learned? Well, obtain any IP rights in the trademark before you register. Yes. Now, I did have a question about evergreening, but the people that are presenting for week 9, hello to you people if you're out there watching this video, they will tell us all about evergreening, so we don't really have to worry too much about that this evening. Does that all make sense? Yes? Any queries or questions about the whole trademark side of things? One thing I did want to mention, I know that I have said something about it in the forums or in an email, I can't remember which, but we do have an excellent online resource now available. I'm still trying to get the copyright commentary up and running for us, but we do have the patents, trademarks and related rights commentary by Lahore, which is wonderful. It's like the Bible of IP law. He also does a commentary on copyright, which is the one I'm trying to get. But if you have any queries or questions in relation to patents or trademarks, go to the library webpage and get into, I think it's LexisNexis, and in there, in the commentaries, you'll see patents, trademarks and related rights in there. And it's very detailed, very well written, and pretty much any search term that you put in there, you'll find something on. So if the text leaves you in some doubt about a point and you want clarification, you can zip online, go to the library, go to the patents, trademarks and related rights database, and I'm sure it will answer any queries that you have. Might also be useful for your end of term assignment if you're doing research on that. I would, and if it's got anything to do with patents or trademarks, I'd be jumping into that commentary on the library website and having a look at that. As I said, I'm still trying to get the copyright stuff up online for you, but at least we've made a start and we've got the patents and trademark stuff up there for you. Any other queries, ladies and gentlemen? I'll stop sharing now so I can see all of your lovely faces. Anything else? No? All right, well, the only last thing I wanted to say was if you're thinking about your presentation, I know it's not till after the midterm break, which is from the 10th to the 14th of April. The presentations don't start till week 8, so that's the 1st of May through to the 22nd of May, those weeks there. It seems like it's a long way away, but I probably would recommend touching base with your fellow colleagues that are presenting in your week. And perhaps exchange emails just so that you have a trustworthy means of getting in touch with each other. I have had a few groups say to me that the forums were proving a bit difficult to work with. So that's just a suggestion. But if you are having any difficulties or problems, queries with your group presentation, please come see me sooner rather than later, because it's much easier to get things sorted out, you know, at the front end than the back end. The other thing was, I did ask you if your group wanted to tweak your presentation at all, to get back to me by yesterday. I have had one group come back to me and they have tweaked, and that is the one that I've told you tonight. The week 9 group is now presenting on evergreening rather than biopiracy. But like I said, get together with your group members, have a chat. I believe that most groups are happy with what they're doing, but if there are any problems or queries, just let me know. Okay? Cool. Well, thanks, guys. And that was Trademarks. Blip, blip. And we'll come together next week for passing off and a bit more on the ACL. Okay? Thanks, guys.
Thanks, AJ.
Bye.
Thanks, bye.
Bye, Joselito. Nice work on this week's question, the competition question. Thanks. See ya.